and welcome back to The Legal Take, where we break down the law behind today's biggest headlines with clarity, context, and real-world insight. I'm Andrea, and today we're diving into a case that could have major consequences for the future of streaming and for how massive entertainment mergers are reviewed under U.S. antitrust law. A consumer antitrust class action has just been filed, challenging Netflix's proposed $72 billion acquisition of Warner Bros. Discovery. The lawsuit claims the deal would dramatically reduce competition in streaming, leading to higher prices, fewer choices, and less innovation for consumers. This isn't just about Netflix. The case could influence how regulators, courts, and companies evaluate mega mergers in entertainment going forward. Let's break down what's happening and why it matters. At the center of this lawsuit is a proposed acquisition that would reshape the media landscape. Netflix, already the largest streaming platform in the world, is seeking to acquire Warner Bros. Discovery, the parent company of HBO and Max, Warner Bros. Pictures, CNN, DC Entertainment, and a massive film and television content library. Together, the combined company would control one of the largest streaming subscriber bases globally, a vast back catalog of premium content, and significant leverage over pricing, distribution, and licensing. Supporters of the deal argue this would help Netflix compete with other giants like Disney and Amazon. But critics say it would do the opposite, entrench dominance and reduce competition. This case isn't being brought by a rival company or a regulator. It's being brought by consumers, specifically streaming subscribers, in a class action antitrust lawsuit. The plaintiffs' allegations include that the merger would substantially lessen competition in the streaming market. Netflix would gain outsized control over premium scripted content. Consumers would face higher subscription prices. Innovation would slow as competition decreases, and smaller or mid-sized streaming services would be pushed out. The lawsuit is grounded in Section 7 of the Clayton Act, which prohibits mergers whose effect may be substantially to lessen competition. This is a forward-looking law. Plaintiffs don't need to show that harm already occurred, only that it's likely. What's important here is who is bringing the case. Everyday subscribers, not competitors. That matters legally. Consumer antitrust cases face a higher bar than government enforcement actions. Plaintiffs must plausibly allege, number one, a relevant market. The first thing a court has to decide in any antitrust case is what market we're actually talking about. That sounds simple, but often it's the most contested issue. In this lawsuit, the plaintiffs argue that the relevant market is premium subscription video streaming services. Platforms consumers pay for monthly to access professionally produced movies and television shows on demand. That definition excludes free ad-supported platforms like YouTube, social media entertainment like TikTok or Instagram, video games, and traditional cable or broadcast TV. Why does this matter? Because antitrust law looks at whether consumers can reasonably switch from one product to another if prices rise. If Netflix raises its prices, can consumers realistically replace it with TikTok or YouTube? The plaintiffs argue no. Those services don't offer the same type of long-form scripted content. Netflix, on the other hand, will likely argue for a much broader market, claiming it competes with all forms of entertainment for consumer attention and dollars. The broader the market, the weaker the monopoly claim. This battle over market definition could determine the outcome of the case. The second point is market concentration. Once the market is defined, the next question is how concentrated is it? Market concentration measures how much power is held by the largest players in a market. Courts often use metrics like market share and the Herfindahl-Hirschman Index, or HHI. Under the plaintiff's theory, Netflix already holds a dominant share of the premium streaming market. Warner Bros. Discovery controls a massive share of must-have content through HBO, Warner Bros. Films, and DC properties. Combining the two would significantly increase concentration in an already consolidated market. High market concentration raises red flags because it makes it easier for companies to raise prices, reduce output, or limit consumer choice without fear of losing customers. Netflix will likely argue the streaming market is crowded, entry barriers are low, consumers can cancel or switch easily, and competition from companies like Disney, Amazon, and Apple keeps prices in check. The court will need to decide whether this merger crosses the line from competitive to dangerously concentrated. Next up, we have anti-competitive effects. The court looks at what the merger is likely to do to competition, not what it has already done. This case focuses on several alleged anti-competitive effects. The first one is reduced competition for premium content. By acquiring Warner Bros. Discovery, Netflix would control both the platform and a massive share of high-demand content. Plaintiffs argue that this could make it harder for rival streaming services to license popular shows or films. Number 2 is increased market power. With fewer serious competitors, Netflix could gain power to raise subscription prices, impose less favorable terms, reduce investment in new content, and bundle services in ways consumers can't easily afford. The last point is barrier to entry. Smaller or emerging streaming platforms may find it impossible to compete against a company that controls both distribution and content creation at this scale. Netflix will argue that the merger would create efficiencies, like better content production and distribution, that actually enhance competition. Courts must weigh those claimed benefits against the risk of harm. And the final point that plaintiffs must allege is consumer harm. Antitrust law asks the most important question: how are consumers likely to be harmed? The plaintiffs argue consumer harm could take several forms, the first being higher prices. With fewer competitors, Netflix could raise subscription fees without losing significant numbers of customers. Plaintiffs point to past price increases as evidence that consumers already have limited alternatives. Next would be a reduced output. Output doesn't just mean quantity. It includes fewer new shows, shorter seasons, lower production quality, and less diverse programming. And last would be less innovation. When competition declines, companies often innovate less. This lawsuit argues that competition among streaming platforms drives better content, features, and pricing, and consolidation weakens that pressure. Netflix will respond that consumers can cancel at any time and that competition is fierce. The court must decide whether that theoretical choice translates into real-world protection. To win, the plaintiffs don't need to prove all of this has already happened. They only need to plausibly show that the merger may substantially lessen competition, a deliberately lower threshold designed to stop harm before it occurs. That's what makes this case so consequential. Plaintiffs' distinguishing point is defining the market as premium subscription streaming services, not all entertainment, not YouTube, not social media. That distinction is crucial. Courts increasingly reject arguments that everything competes with everything. Streaming services are evaluated as their own market. The lawsuit focuses on 3 main arguments. Number 1, market concentration. Netflix already dominates streaming. Adding Warner Bros. Content library would significantly increase its control. Number 2, vertical and horizontal effects. This isn't just a content acquisition. It's also about distribution of power. Netflix would control production, licensing, distribution, and consumer access. And number 3, consumer harm. The plaintiffs argue the likely effects would include higher monthly subscription prices, fewer competitive alternatives, bundling or exclusivity practices, and reduced incentive to innovate. This aligns closely with modern antitrust enforcement priorities under the Biden administration. Netflix has yet to file a full response, but based on past cases, we can anticipate their strategy. Defense number one is that there is still a broad market. Netflix will argue that it competes with Disney Plus, Amazon Prime, Apple TV Plus, YouTube, TikTok, gaming, and social media. The broader the market they can demonstrate, the weaker the monopoly claim becomes. Defense number two is that consumers will benefit from this deal. Netflix will likely argue there will be lower prices due to scale, they'll be able to provide better content, their production will become more efficient, and they will become a stronger competition against big tech. Defense number three is that there is a regulatory approval process in place to ensure consumer protection. Netflix may point out that the DOJ and FTC review mergers, so courts should defer to regulators. Consumer lawsuits shouldn't override the expertise of the agencies, whose purpose it is to review and regulate these sorts of transactions. This lawsuit doesn't exist in a vacuum. It fits into a broader shift in antitrust enforcement. The DOJ and FTC are more aggressive in recent history than they were in the past. For decades, federal antitrust enforcement was relatively restrained. Beginning in the late 1970s and accelerating through the 1990s and early 2000s, the prevailing philosophy was that markets usually correct themselves, and mergers were generally allowed unless clear price increases could be proven. That approach has shifted dramatically. Today's Department of Justice and Federal Trade Commission are actively challenging mergers that would have sailed through approval 10 or 15 years ago. This includes deals in airlines, publishing, healthcare, tech, and now entertainment. So what's driving this change? First, there's a growing belief that excessive consolidation has reduced competition. There's also evidence that prices have risen even where efficiencies were promised. And last, concern that dominant firms are entrenching power rather than competing. Under the current enforcement posture, regulators are more willing to block deals outright, not just negotiate behavioral conditions. This lawsuit against Netflix fits squarely into that more aggressive climate, even though it's filed by consumers rather than regulators. The next change is that courts are reconsidering decades of merger-friendly precedent. For a long time, courts were heavily influenced by the so-called consumer welfare era of antitrust law, a period when judges were reluctant to block mergers unless they could see immediate, measurable harm. That judicial mindset has changed. Recent court decisions show increased skepticism toward arguments that mergers automatically lead to efficiencies or consumer benefits. Judges are more willing to scrutinize market structure, barriers to entry, and long-term competitive effects. Importantly, courts are beginning to acknowledge that once competition is lost, it is extremely difficult to restore. As a result, courts are becoming more open to preventive enforcement, stopping consolidation before harm becomes irreversible. That shift could make judges more receptive to challenges like this one. The next change is that consumer harm is being analyzed more realistically. In the past, antitrust analysis often focused narrowly on price, asking whether a merger would immediately cause prices to rise. Today, courts and regulators take a broader, more realistic view of consumer harm. They now consider declines in quality, reduced innovation, fewer choices, and less pressure to improve services. In subscription-based markets like streaming, consumer harm doesn't appear overnight. Instead, it may show up gradually. The final point of change is that entertainment and tech are under heightened scrutiny. This case is part of a broader reevaluation of consolidation in entertainment and technology, two industries that increasingly overlap. Streaming platforms are no longer just content distributors. They are studios, publishers, data companies, advertising platforms, and gatekeepers to consumer access. Regulators and courts are increasingly wary of companies that control both what content gets made and how audiences access it. High-profile scrutiny of big tech companies like Amazon, Apple, Google, and Meta has influenced how courts view power concentration in adjacent industries like streaming. Entertainment mergers that once looked harmless are now being evaluated as platform power plays, with potential ripple effects across culture, commerce, and speech. That context makes the Netflix Warner Brothers lawsuit especially significant. Taken together, these shifts create a legal environment that is far less forgiving of massive consolidation than in the past. Even if Netflix ultimately prevails, the fact that this lawsuit is being taken seriously reflects a fundamental change in how antitrust law is being enforced and interpreted in the United States. This case isn't an outlier. It's a sign of where antitrust law is heading. Recent cases involving big tech, airlines, and publishing companies show courts are more willing to block or scrutinize large mergers. This case could test whether streaming joins that list. If the plaintiffs succeed, even preliminarily, the consequences are significant. First, the deal could be delayed or blocked. The most immediate consequence of a successful consumer lawsuit would be delay, and potentially a full stop. Even if regulators haven't formally blocked the merger, a court can issue an injunction, preventing Netflix from closing the deal while the case proceeds. That alone can be devastating to large transactions, because uncertainty drives up costs, scares investors, and can cause financing to fall apart. If the court ultimately agrees that the merger violates antitrust law, it could block the acquisition entirely, preventing Netflix from acquiring Warner Brothers Discovery as proposed. Importantly, courts don't need to prove harm has already happened, only that the merger may substantially lessen competition. Another consequence is that Netflix could be forced to divest assets. Even if the court allows the merger to proceed in some form, it could require structural remedies, also known as divestitures. That means Netflix might be forced to sell off certain studios or content libraries, license valuable intellectual property to competitors, or spin off business units to preserve competition. Structural remedies are considered the strongest form of antitrust relief because they permanently change the market structure, not just company behavior. Courts and regulators increasingly prefer divestitures over promises of good behavior, especially in fast-moving digital markets. Another possible outcome is behavioral remedies, which are court-ordered rules governing how Netflix can operate post-merger. These could include prohibitions on exclusive content deals, requirements to license content to competitors on fair terms, limits on bundling services or pricing strategies, and firewalls between content creation and distribution. While behavioral remedies allow a deal to move forward, they require ongoing oversight, and courts have grown more skeptical of their effectiveness. Still, they remain a tool judges can use when full blocking feels too extreme. Another consequence is that future streaming mergers would face tougher scrutiny. A plaintiff victory here would send a strong signal across the entertainment industry. Streaming companies considering mergers would face higher litigation risk, longer review timelines, more aggressive discovery demands, and increased likelihood of injunctions. Deals that once seemed routine could now face intense legal and regulatory resistance, not just from the government, but from private consumers. This could slow down consolidation across streaming and media more broadly. And finally, consumer lawsuits would become a more powerful antitrust tool. Perhaps the most far-reaching consequence would be the empowerment of consumer antitrust litigation. Historically, large merger challenges were dominated by regulators or competitors. A win in this case would demonstrate that consumers can successfully challenge major mergers. Courts are receptive to forward-looking harm arguments, and private plaintiffs can influence national competition policy. That could lead to a wave of new consumer-led antitrust suits, not just in streaming, but in tech, healthcare, airlines, and beyond. In effect, consumers would become a frontline force in antitrust enforcement. Taken together, these outcomes would reshape how companies evaluate mergers, how courts assess competition, and how consumers can assert their rights under antitrust law. This case isn't just about Netflix. It's about who gets to police market power in the modern economy. A win for plaintiffs would embolden private plaintiffs to challenge entertainment consolidation more aggressively. If Netflix defeats the lawsuit, the immediate outcome is that the merger will likely proceed. If the court dismisses the lawsuit or rules in Netflix's favor, the most immediate consequence is straightforward. The deal moves forward. A win would clear a major legal obstacle and signal that the court does not view the merger as a serious threat to competition. That outcome would likely accelerate closing timelines and reduce regulatory hesitation. Just as important, a favorable ruling would give Netflix and similar companies a legal roadmap for defending large mergers in court. Another effect is that market consolidation could accelerate. A Netflix victory wouldn't just affect this one deal. It would influence the entire streaming industry. Companies watching this case would interpret it as confirmation that courts remain skeptical of aggressive merger challenges. High market share alone is not enough to block consolidation, and broad market definitions still carry weight. As a result, other streaming platforms and entertainment companies could move more aggressively toward mergers, acquisitions, and strategic combinations. In short, consolidation would likely speed up, not slow down. Another possible outcome would be that consumer antitrust suits would face a steeper uphill battle. One of the most significant ripple effects would be on consumer-led antitrust litigation. If Netflix prevails, it could reinforce the idea that consumers struggle to prove standing in merger cases. Forward-looking harm theories are too speculative, and courts prefer enforcement by regulators rather than private plaintiffs. That would raise the bar for future consumer suits, making them harder to bring and harder to win. Private antitrust enforcement would remain possible, but significantly less powerful. And finally, streaming platforms would gain more leverage over pricing and content. A Netflix win could shift the balance of power further toward major streaming platforms. With fewer legal constraints on consolidation, dominant companies could gain greater leverage to increase subscription prices, reduce investment in riskier or niche content, favor proprietary content over licensed materials, and dictate terms to creators, distributors, and consumers. While competition wouldn't disappear overnight, the pressure that keeps prices low and content plentiful could weaken over time. That kind of gradual shift is precisely what antitrust law is meant to prevent. But it's also the hardest harm to prove in court. A Netflix victory would reinforce a more traditional, merger-friendly approach to antitrust law, one that prioritizes efficiency and scale over structural competition concerns, and signal that courts remain skeptical of consumer-led merger challenges, despite regulatory rhetoric. For consumers, the impact wouldn't be immediate, but it could shape the streaming landscape for years to come. This case isn't just about Netflix and Warner Brothers. It could influence Disney acquisitions, Amazon studio expansions, big tech content deals, the future of vertical integration in media, and how courts define competition in digital markets. In short, it's a bellwether case. This lawsuit highlights a growing tension in American antitrust law. Should courts allow massive consolidation in the name of efficiency, or step in to protect competition before consumers are harmed? As streaming becomes the dominant form of entertainment, how we answer that question will shape the industry for decades. I'll be watching this case closely, and I'll keep you posted as it develops. Thanks for watching The Legal Take. If you found this breakdown helpful, be sure to subscribe, like, and share. I'm Andrea, and this has been your Legal Take. And as always, until next time, stay informed, stay curious, and stay legally minded.